Supreme Court allowed the appeal in the matter of JOYI Kitty Joseph versus Union of India and set aside the order of detention and held that Detenu shall be released forthwith if still in custody. Court stated that three grounds are raised before us to secure the release of Detenu, who is behind bars for almost a year, the arrest being on 5 March 2024. That there is clear non application of mind since allegations are raised in clauses 1 to 4 of Section 3(1) of the Coffee Act in an omnibus manner, clearly revealing the bias of the detaining officer. The attempt was to somehow obtain preventive detention of the person who was arrested on basis of offences alleged, in which crime he was granted bail by the jurisdictional court imposing very stringent conditions. Then the department had moved an application for cancellation of bail, which was never pursued, and importantly, said application was not placed before the detaining authority. The detaining authority thus did not have the opportunity to consider the grounds raised for cancellation of bail and to consider as to why preventive detention should be made when such an application for cancellation of bail was pending before the competent court. A cancellation would have resulted in Detenu being taken back in custody, in which event there was no cause for shackling the appellant on preventive basis. When a judicious consideration was possible as to whether the appellant should be taken back in custody, an order for preventive detention ought to have been avoided, which would also be in violation of statutory provisions under Article 14, 19, and 21 of the Constitution of India 1951. The last ground urged is that impugned order referred to a conviction in a case involving narcotics, which conviction is challenged before the Honorable Supreme Court by way of appeal, in which Detenu is also released on bail. Crime itself was registered way back, and the incident has no live link with the order of detention. It was also urged that proviso to Section 3(1) of Coffee Act specifically prohibited detention under that provision if an order of detention can be made under Section 3 of Narcotics, Drugs and Psychotropic Substances Act 1985. In present case, it has been clearly substantiated, said Supreme Court, that the Detenu was at the helm of affairs of the smuggling of gold, a continuing activity wherein he had engaged carriers to carry out smuggling, from whom smuggled goods were received either by him or his wife alone or together and then transmitted to agents who would sell them in the market on cash basis without invoices or bills. The proceeds of which, minus the commission, was received by Detenu. There is a complete chain of activity revealed which commences with the Detenu and ends with him, bringing in the ingredients of all the four provisions. Detenu was found to be a habitual offender and a key person of well organized syndicate involving smuggling and disposal of foreign goods brought illegally into India, which activity was habitually carried out throughout his associates without declaration before the custom authorities and without payment of applicable duties. The smuggling of gold was for the purpose of illegal profiteering, putting the national economy into danger, which activity was sought to be curbed by the detention order. Detenu was found to have indulged in activities amounting to smuggling under both the Customs Act and Coffee Act. Detenu was also found to have an innate propensity to devise ways and means to smuggle foreign gold into India, which was done through well organized smuggling network and established mechanism operated through trusted associates. The habitual indulgence in such fraudulent activities by way of smuggling goods, abetting of smuggling of goods, engaging in transporting and concealing or keeping the smuggled goods and dealing in such smuggled goods at cost of government revenue and national security was found to be with a clear motive of illegal enrichment with no concern to the general economy and national security interests. The Detenu was found to have played a vital role in smuggling foreign original gold through organized network and executing disposal of such smuggled goods with meticulous planning and deliberate design regardless of consequences to the society at large. Detnu had officially changed his name from Afzal Haroon Batatawala to Samir Haroon Merchant, in which name he was arrested in a case of gold smuggling in the year 2017. Court said we do not find any reference made to allegations in narcotics case in operative portion of detention order. It cannot be disputed that there is no live link with arrests in narcotics case in which by year 2013 he had spent 9 years of sentence awarded. Court said that reference to NDBS case is only to emphasize the propensity of the detainee to involve in such illegal activities by even changing the name officially to suppress his real identity. We do not find any reason to hold the detention to be illegal on ground of a mere reference to NDPS case, which we reiterate is only to emphasize the change in name resorted to by the detenu after being released on bail. The criminal prosecution launched and the preventive detention ordered are on the very same allegations of organized smuggling activities through a network setup revealed on successive raids carried out at various locations on specific information received, leading to recovery of huge cash of contraband. When bail was granted by jurisdictional court, that too on condition, detaining authority ought to have examined whether they were sufficient to curb the evil of further indulgence in identical activities, which is the very basis of preventive detention order. The detention order being silent on that aspect, court said that we interfere with the detention order only on the ground of detaining authority having not looked into the conditions imposed by the magistrate while granting bail for the very same offense. The allegations in which have also led to preventive detention assailed herein to enter a satisfaction as to whether those conditions are sufficient or not to restrain the detenu from indulging further like activities of smuggling.